Contemporaneous legal discourse is often paralyzed with substantive arguments that both oppose and favor a particular question of law from seemingly equally merited standpoints. Illegality is a podcast that delves into often conflicting but equally incontrovertible aspects of legal discussion and provides listeners the opportunity to know all schools of thought governing legal issues. From the Journal and Seminar Committee of Department of Law, University of Calcutta, and co-hosted by Atreya Chakraborty and Samriddha Sen.
Hello everyone, welcome to Legality, the weekly podcast of the Journal and Seminar Committee of the Department of Law, University of Calcutta, co-hosted by Atreya Chakraborty and I, Samriddha Sen, where we delve into the merits of conflicting arguments in legal discourse. For the third episode, we will be discussing the legal framework currently in place that supports the federal and state government's COVID-19 response mechanism, which includes the Epidemic Diseases Act of 1897, the Disaster Management Act of 2005, the lockdown orders which have been granted thereon, its constitutional relevance or implications, as well as the prospects of a constitutional emergency which could be granted from the same response framework. As a concluding segment, we also discuss some key observations in an attempt to balance public health objectives with civil liberties, and as an extension of it, what are the prospects of civil liberties in a post-pandemic world. It is reminded to all listeners that any and all opinion given over the course of this episode are solely our own. Desperate times often call for desperate measures, at least that's how the saying goes. The novel coronavirus of 2019 or COVID-19 with all its might and hubris has come at a time when democracies are at a flashpoint. Sectarian violence, divisive politics and tyrannical governance. Some of the many elements of democratic corrosion have attained a trend of rapid expansion across the eastern and western hemispheres. Authoritarianism in the time of a global pandemic may appear facially justified and necessary, but its overwhelming justification poignantly leaves behind a stark reminder, which is governments empowered with the tools of universal oppression will seldom voluntarily relinquish control over it. This, what you could call legislative desperation, almost invariably gives a short thrust to legally owed rights and liberties in the name of the quote public or quote national interest. The thing is, there is no legal definition of what these phrases could imply, other than the standardized interests of the state, including but not limited to national security, territorial and integral sovereignty. Thus, not only are the meaning of such phrases, the phrases being public interest or national interest, the meaning of such phrases are not only superfluous. Once read along with existing emergency or national security interests, you can probably gauge on how wide the discretion and authorities of the state can be extended. A perfect introductory case study concerning how legislatures subvert constitutionalism during emergency or challenging circumstances by passing draconian laws would be the Patriot Act of the United States of America. Passed near unanimously by a Congress reeling under the effects of 9/11, the act is prima facie violative of the First, Fourth, and Fifth Amendments of the United States Constitution. Edward Snowden, a former CIA contractor who exposed the NSA's massive wiretapping and data surveillance program, in an interview with the Copenhagen International Documentary Film Festival, as reported by CNET, said, "When we see emergency measures passed, particularly today, they tend to be sticky as in referring to the Patriot Act." Snowden also said governments could extend the access they have to monitor people's personal information during a crisis. During the coronavirus outbreak, governments could raise concerns about public health and send orders to smartphones and fitness trackers for information about pulse and heart rates. Once the pandemic ends, the same mechanism can be used in the pretext of other fears such as terrorism, thereby continuing to gather the same kinds of data. Snowden's concerns appear to be legitimate when he says, "They already know what you're looking at on the internet, they already know where your phone is moving, now they know what your heart rate is, what your pulse is." What happens when they start to intermix these and apply artificial intelligence analysis to it? Same applies for the Armed Forces Special Powers Act of 1958 and the erstwhile Maintenance of Security Act of 1971, which subsequently broke up into the National Security Act of 1980, Terrorism and Disruptive Activities Prevention Act or TADA of 1985, and the Prevention of Terrorism Act or POTA of 2002. The only distinction I can conjure up between the American and Indian case studies, other than the differences involving prescriptive nature of statutes, is that unlike the American example where every statute is subject to a constitutionality check through judicial review, as you may have known about Marbury versus Madison, the Indian example differs widely because of socialist principles being bad in law, which led to the emergence of the Ninth Schedule, as I'm sure you're aware I have discussed in relative detail in the first episode of our podcast. MISA, enacted by the Indira Gandhi regime in 1971, was made immune from judicial review by parking it within the Ninth Schedule until it was repealed by the 44th Amendment Act of 1978. Because of the impossibility of judicially reviewing preventive detention and other security orders passed under MISA, the Act had the historical reputation of being one of the most misused security laws in India, resulting in custodial deaths, forced sterilizations, indefinite detentions, mind you without trial, and arbitrary arrests. History, thus both domestic and international, is replete with examples that validate such skepticism. Such examples, while not a perfect case study for addressing civil liberties concerns during global pandemics, often offer insight as to how governments are predisposed to subvert constitutionalism on account of political convenience and expediency. In regard to the Indian legal framework which supports COVID-19's response policy, we will be discussing the statutes which have been invoked by the central and state governments, the constitutionalities thereof, the orders that have been passed thereunder, and whether a constitutional emergency can be declared to combat COVID-19. First, we'll discuss the two major statutes which have been invoked at various levels of the central and state government's pandemic response. These are the Epidemic Diseases Act of 1897, the Disaster Management Act of 2005, as well as discuss whether an emergency can actually be declared on the present response framework, as well as whether the lockdown satisfies the reasonable test of Article 19. The Epidemic Diseases Act 1897 was enacted with the aim to better prevent the spread of the bubonic plague, which originated in Bombay, now Mumbai, in September of 1896. More precisely, the said Act of 1897 was promulgated with the aim of better prevention of the spread of dangerous epidemic disease. The said Act is 123 years old and contains only 4 sections. Irrespective of the Act's antiquity and extreme brevity, its provisions have been consistently utilized in an attempt to thwart the spread of the extremely dangerous and highly contagious SARS-CoV-2 virus. Although there is a possibility that the Epidemic Diseases Act 1897 may ultimately prove to be an indispensable tool in the fight against the said virus, some of the Act's limitations cannot be ignored. These limitations have been addressed in the following discussion. At this juncture, it is necessary to mention that the then legislators responsible for promulgation of the Act of 1897 were so steadfast in assuring the brevity of the Act that none of the sections in the Act define the term epidemic disease. The absence of a clause providing for a definition of the phrase epidemic diseases could be viewed as an attempt to evade interpretative rigmarole involved in designating a type of disease as an epidemic in accordance with a one-size-fits-all legislative definition. At the same time, however, the absence of such definition bestows a little too much discretion upon the government or the concerned administration in deciding which disease does or does not qualify as an epidemic, warranting the application of the Act. In other words, it is of utmost importance to designate as to who decides what a dangerous epidemic disease is and what criteria such definition is based on in order to enhance transparency and mitigate misuse of the Act. Moreover, a reading of the Epidemic Diseases Act makes it evident that it fails to strike a balance between the powers conferred upon the central and state governments during an epidemic and the rights of the citizens. It goes without saying that in a democratic country such as India, even during a pandemic, howsoever difficult it might be, due recognition must be provided to individual autonomy, liberty, and privacy. More importantly, the Act does not lay down the requirement of any standard of safety whatsoever to be ensured by the government in order to protect healthcare officials, doctors, and other medical staff from the perils of infection. Furthermore, as highlighted in the Indian Journal of Medical Ethics, when we have a better structured public health system with specific people in charge of delivering primary care services, the prevention of outbreaks of epidemic diseases and their control is the responsibility of primary caregivers. The IDSP is in place for early detection of outbreaks.
the district chief medical officer, along with the district level team and the primary health center medical officer, field workers, and other community health workers, led the workforce for the control and prevention of outbreaks. When such a system is in place, going by the Act's prescription that any person may be empowered does not make sense. The word any cannot be accepted in the current context, and who can do what needs to be specified. Another drawback of this Act is that it does not conform to contemporary scientific understanding of outbreak prevention. Its overt emphasis on isolation and quarantine measures hark back to the era when it was promulgated. Instead, it should give more importance to other specific and more effective measures of outbreak control, such as vaccination, disease surveillance, and organized public health response. Lastly, a perusal of the Act makes it evident that there is a complete lack of prescription of legislative policy with respect to the method of implementation of the powers delegated upon the central and state governments by virtue of sections 2A and 2 of the Act respectively. Such carte blanche delegation of authority by a statute makes it susceptible to the vice of unconstitutionality on ground of legislative abdication. Now let us move on to the discussion of constitutionality of nationwide lockdowns for pandemic response. By its very nature, the ambit of Section 2 of the Epidemic Diseases Act is wide enough to allow a state or a lower functionary in the administration dealing with an emergency caused by the outbreak of a dangerous disease to seek or require the cooperation of the public or corporate bodies in the public or private sectors. If the desired cooperation is not forthcoming, a regulation may also be imposed. Failure to obey or comply with such restrictions imposed by such a regulation constitutes a punishable violation. On the basis of the existing legal apparatus, it can thus be argued that the powers of segregation or quarantine that the central and state governments enjoy may impinge on the political and civil rights of the public. Fundamental rights as guaranteed by the Constitution of India are justiciable and therefore subject to reasonable restrictions. Quarantine is a measure that adversely affects the fundamental right to move freely throughout the territory of India. As we have discussed earlier, Section 4 of the Epidemic Diseases Act includes a protection clause that gives state immunity such that no suit or legal proceeding can be brought against any person for anything done or in good faith intended to be done under this Act, thereby absolving the state from any legal liability for acts done in pursuance of epidemic response. As evident from the 2003 SARS outbreak in India, where many patients were reported to have faced severe quarantine measures and discriminatory practices out of lack of privacy safeguards, such instances cannot be legally permissible under the present jurisprudence. While such measures were often bolstered by applications of the Epidemic Diseases Act read along with the Disaster Management Act, privacy has now been deemed as a fundamental right under Article 21 of the Constitution, thereby raising further concerns on the legitimacy of such statutory practices. The central government, acting through the Ministry of Home Affairs, vide Memorandum number 40-3/2020-DM-IA, had imposed a countrywide lockdown by invoking its powers under the Disaster Management Act 2005 in order to combat the rapid spread of the SARS-CoV-2 virus. Undoubtedly, the lockdown imposed by the central government is a necessary measure for combating the spread of the virus, and therefore it may well be considered as being a part of its positive obligation to safeguard public health. Such construction stands well supported in light of the decision of the Supreme Court in the matter of State of Punjab versus M.S. Chawla. In the said matter, the apex court had ruled that right to health is integral to the right to life. Therefore, upon giving weight to the prevalent circumstances, one can most certainly argue that the mandate of protection of public health far outweighs the need of individuals to enjoy the finer aspects of the right to life and other fundamental rights. When speaking of fundamental rights other than the right to life, one cannot help but notice that the lockdown primarily affects two distinct fundamental rights guaranteed under Article 19(1)(d) and (g) of the Indian Constitution, namely the right to move freely throughout the territory of India and the right to carry on any occupation, trade or business. While considering the overall effect of the lockdown on these aforementioned fundamental rights, one must not lose focus of Clause 5 under Article 19, which speaks of reasonable restrictions on the rights guaranteed under Article 19(1) subclauses A to E and G. The answer to the question as to whether the lockdown imposed by the central government can be perceived as a valid and reasonable restriction upon the said freedoms is basically twofold. Firstly, it shall be prudent to draw our attention to the ruling laid down by the Supreme Court in the matter of Bijo Emmanuel versus State of Kerala, wherein it was held that law as contemplated by clauses 2 to 6 of Article 19 to regulate the exercise of the right to freedoms guaranteed by Article 19(1)(a) to E and G must be a law having statutory force and not a mere executive or departmental instruction. Now, I would like to argue that even though the directions effectuating the present lockdown issued by the National Disaster Management Authority might appear to be purely executive in nature, the said directions having been issued as per the provisions contained under Section 2, under Section 6, subsection 2, subclause 1 of the Act of 2005, bear statutory force and can be considered to be law as contemplated by clauses 2 to 6 of Article 19. Such argument, however, is subject to negation by my co-host. Secondly, in the matter of Lakshmi Khansari versus State of UP, the apex court had held that the restrictions contemplated under Article 19 Clause 5 must be in public interest and should strike a balance between the deprivation of the right and the danger of the evil sought to be avoided. Although the affluent might have the luxury to view the present situation of virtual house arrest as being necessary for preservation of life caused due to the lockdown, is a severe setback. It is a severe setback to the migrant workers, small traders, and street vendors. The present situation not only hampers their rights of free movement and carrying out trade, but also subverts their right to livelihood. Thus, one might not be too sure of labeling this restriction imposed by the lockdown to be entirely reasonable unless the government rolls out policies ensuring rehabilitation of those most severely affected by the said lockdown. However, the reality is that the difficulty in taking a firm stand against the reasonability of the said restriction arises out of the acute dearth of foolproof measures that could be undertaken by the government for the purpose of ensuring all-round protection of rights of all individuals. Now, upon a deeper contemplation, it can be stated that a conclusive opinion with respect to the reasonability and consequently the legality of the lockdown imposed by the central government as per the provisions of the DMA ultimately hinges on the analysis of the question as to whether the provisions of the Act of 2005 can be invoked in case of an epidemic. Such question shall be dealt with in detail by my co-host in the following portion of the discussion.
The Disaster Management Act of 2005 is the second statute which has been invoked by the central government as a part of its COVID-19 response policy. The Objects and Reasons clause of the Act states that its operations are intended to provide for the effective management of disasters and for matters connected therewith or incidental thereto. Section 2D of the Act defines disasters as a catastrophe, mishap, calamity, or grave occurrence in any area arising from natural or man-made causes or by accident or negligence which results in substantial loss of life or human suffering or damage to and destruction of property or damage beyond the coping capacity of a community of an affected area. Thus, while a cursory look at the Act makes it clear that the statute does not bear the legislative intention to combat viruses or pandemics, but rather natural calamities and disasters such as floods and earthquakes, a more detailed discussion of this Act is needed. To mandate an apparently legal invocation of the Disaster Management Act of 2005, the central government on the 14th of March 2020 declared the novel coronavirus of 2019 as a notified disaster which causes a, quote, medical condition or pandemic situation. Section 11.3 of the Act sets out the aspects of such a plan. It is to deal with the measures to be taken in mitigation and to address preparedness and capacity. Section 19 mandates the state authority to lay down guidelines for providing standards of relief. Section 22(2)H permits the state authority or executive committee to give directions to government departments on actions to be taken in response to any threatening disaster. Sections 24 and 34 empower the state executive committees and district authority to control or restrict the movement of vehicular traffic or people from or within a vulnerable or affected area and to take any measure that may be warranted by such a situation, among others. Additionally, directions can be given to government departments on taking such steps and measures for rescue, evacuation, providing immediate relief, saving lives. Section 30 replicates this model for the district level. Section 35 permits the central government to take such measures as A. Coordinate work between the various authorities and government departments, B. Deployment of military forces, and C. Other matters to secure effective implementation, among others. Section 36 creates a statutory responsibility on all central government departments to comply with the directions of national authority. The Act also requires all government departments to formulate their own disaster management plans, as well as access to appropriate funds for rapid response and relief operations, which are the national, state, and district disaster response funds. Section 46 of the Act authorizes the National Executive Committee and the National Disaster Management Authority for the usage of such funds for emergency responses, relief, and rehabilitation. Section 47 of the Act empowers the central government to constitute a National Disaster Mitigation Fund. Section 50 authorizes, in times of a threatened disaster, the authorities to permit the administration to procure without adherence to the usual tender process, procurement usually relating to safety equipment and other associated infrastructure that are required for first responders and other personnel in the field. Section 51 sets an imprisonment term for 1 year or 2 years in the event of a loss of life for persons obstructing discharge of functions of any government officer or employee. Section 54 prescribes a 1-year penalty for spreading fake news or false alarm, while Section 56 has a similar penalty for a government servant who refuses to perform his duty. Section 61, on the other hand, prohibits discrimination on grounds of sex, caste, community, descent, or religion in the matter of providing compensation or relief to victims. Section 6 empowers the central government to issue binding directions to authorities and state governments, and lastly, Section 72 gives the statute an overriding effect. While now it is evident that under a logical understanding of statutory phrasing and the absence of any linkage with the Epidemic Diseases Act or a specific intention to combat viruses, we come to the conclusion that the Act has not been enacted by Parliament for combating pandemics or anything of that sort. Such conclusion is apparent through two separate understandings. Number one is that, notwithstanding legislative intent, after textually interpreting specific provisions of the Disaster Management Act, which addresses healthcare responsibilities of federal and state responders, we have found that the Act only imposes healthcare obligations in respect of providing healthcare services in disaster-affected areas by state executive committees, district authorities, central government ministries, and state government departments. Number two is Vidhi Center for Legal Policy's project fellow, Ms. Yogini Oak, argues that even though the Epidemic Diseases Act of 1897 grants unwritten and thus relatively unchecked enabling authority to speedily set up management systems required for a coordinated and concerted response, from a purely legalistic standpoint, however, it is archaic, completely unprescriptive, and a colonial law that fails to meet contemporary health challenges. As this is basically reiterating what my co-host Atreya Chakraborty said on the EDA a few minutes back. Ms. Yogini Oak argues that because of the awareness of such failures, the central government has invoked the Disaster Management Act of 2005 as it provides for an exhaustive administrative setup for disaster preparedness. There is yet another concern about the Act and its invocation which is required to be scrutinized. This is in regard to the notified disaster reference I made at the beginning of my discussion of the Disaster Management Act. One office memorandum of the Ministry of Home Affairs' Disaster Management Division stated that via an earlier letter from the MHA, the government has declared COVID-19 as a quote notified disaster for the purpose of assisting state disaster relief funds in collecting samples and procuring PPEs being personal protective equipments. The concern regarding is that not only does the earlier MHA letter provide any legal basis as to how the government can notify a disaster so as to invoke the application of the DMA itself has no provision for the central government to notify a disaster so as to invite an application of Section 2D of DMA. Taking into all these statutory provisions and analysis into account, specifically that the DMA does not provide any authority to the central government so as to notify a particular disaster, it is evident that none of these provisions specifically envisage combating epidemics or lethal viruses, and thus the only pathway for implementing an act intended for such different purposes is by exploiting merely statutory ambiguity. Our recommendation, if one asks, is that India requires a comprehensive legal framework to address pandemic and or biological threats, which prescribes in detail protocols on various aspects of pandemic response, including but not limited to testing, quarantine, personal protective equipments and medical stockpiles, medical security logistics, center-state cooperation, as well as thresholds under which public health measures would not supersede civil liberties interests. We're working on something in this regard and we will make a public announcement on it once our effort materializes.
Let us now discuss whether constitutional emergency can be declared to combat COVID-19. The imposition of a nationwide lockdown has undoubtedly led to the curtailment of fundamental rights of the citizens guaranteed under the Constitution of India. Many have argued that since the Constitution of India provides for suspension of fundamental rights only during national emergency, the abrogation of such rights due to the nationwide lockdown without a proclamation of emergency is arbitrary and unlawful. One cannot arrive at a decision with respect to the veracity of such argument without assessing the possibility or viability of the imposition of an emergency in response to the SARS-CoV-2 pandemic in the backdrop of the present constitutional provisions. Article 352 of the Indian Constitution contains provisions with respect to the proclamation of national emergency. Prior to the 44th Amendment to the Constitution of India, Article 352 provided for the imposition of national emergency on grounds of war, external aggression, and internal disturbance. Even though the terms war and external aggression were more or less precise and distinct, the phrase internal disturbance was very wide, vague, and expansive in nature. The arbitrary and improper invocation of national emergency by the Indira Gandhi-led administration on 26 June 1975 on the ground of internal disturbance became the driving force behind the 44th Amendment, which ultimately led to the substitution of the phrase internal disturbance with armed rebellion. Therefore, presently, Article 352 of the Indian Constitution provides for the imposition of national emergency on grounds of war, external aggression, and armed rebellion. Even though the term internal disturbance had indeed been subjected to abuse by an autocratic ruler, it could be argued that the said term provided an element of flexibility which could have been useful in the present circumstances. Such element of flexibility can be better explained by drawing a reference to paragraph 6.3.03 of the report of the Sarkaria Commission on Center-State Relations. The said paragraph runs as follows. It is difficult to define precisely the concept of internal disturbance. Similar provisions, however, occur in the constitutions of other countries. Article 16 of the Federal Constitution of Switzerland uses the expression internal disorder. The framers of the Indian Constitution have, in place of this term, used the expression internal disturbance. Obviously, they have done so as they intended to cover not only domestic violence but something more. The scope of the term internal disturbance is wider than domestic violence. It conveys the sense of domestic chaos, large-scale public disorder which throws out of gear the even tempo of administration and endangers the security of the state is ordinarily one such cause. Such an internal disturbance is normally man-made, but it can also be nature-made. Natural calamities of unprecedented magnitude such as flood, cyclone, earthquake, epidemic, etc. may paralyze the government of the state and put its security in jeopardy. A bare reading of the aforequoted excerpt of the report of the Sarkaria Commission reveals that the learned commission had recognized that an epidemic could cause widespread public disorder leading to the disruption of sound administration, thereby warranting the imposition of national emergency on the ground of internal disturbance in general and epidemic in particular. Now, while there may be no impediment towards accepting the pandemic caused by the SARS-CoV-2 virus as being equivalent to internal disturbance, it certainly cannot be covered by any of the three existing grounds in Article 352, which would permit the central government to declare an emergency and suspend fundamental rights, including those guaranteed under Article 19. Furthermore, it could be contended that the constitutional basis for imposition of lockdown without proclamation of emergency could be found under Article 355 of the Constitution of India, which imposes a duty upon the Union to protect each of the states from external aggression, internal disturbance, and to ensure that the government of the state is carried on in accordance with the provisions of the Constitution. Deliberating upon the scope of Article 355 of the Constitution of India, the Sarkaria Commission had made the following observations. In para 6.3.14, the Commission had stated that under Article 355, a whole range of action on part of the Union is possible depending on the circumstances of the case, the nature, the timing, and the gravity of the internal disturbance. In some case, advisory assistance by the Union to the state for the most appropriate deployment of its resources may suffice. In more serious situations, augmentation of the state's own efforts by rendering Union assistance in men, material, and finance may be necessary. If it is a violent upheaval or a situation of external aggression, deployment of the Union forces in aid of the police and magistracy of the state may be sufficient to deal with the problem. In the following paragraph, the Commission goes on to suggest that normally a state would actively seek the assistance of the Union to meet such a crisis. However, the scope of Article 355 is wide enough to enable the Union to render all assistance, including deployment of its armed forces, notwithstanding the fact that the state government has made specific request. Thus, as is plain from the aforementioned excerpt of the report of the Sarkaria Commission, the Union need not wait for a state's request for assistance before rendering the same, either in form of specific guidelines or deployment of armed forces and the like. However, any specific directions or suggestion of measures, including that of a lockdown, provided by the Union as per its duty under Article 355, shall not bear the same force of implementation as in the case of directions issued by the Union during a national emergency under Article 352. Therefore, the Union acting under the mandate of Article 355 would not be permitted to suspend fundamental rights. Moving ahead, let us assess the possibility of imposition of President's rule in light of the prevailing circumstances. In paragraph 6.3.03 of the report of the Sarkaria Commission, it was observed that internal disturbance is no longer a ground for taking action under Article 352. Further, it cannot by itself be a ground for imposing President's rule under Article 356 subclause 1, if it is not intertwined with a situation where the government of a state cannot be carried on in accordance with the provisions of the Constitution. Furthermore, in paragraph 6.4.11 of the report, the Sarkaria Commission, in consideration of an internal disturbance that could be caused due to a natural calamity or epidemic, has stated that only if such calamity or epidemic is of unprecedented magnitude and severity and completely paralyzes the administration of the state, and the state government is unwilling or unable to exercise its governmental power to relieve it, can President's rule be imposed. Now, even though the present epidemic is of an unprecedented magnitude and severity, complete paralysis of any state administration or its unwillingness or acute inability to govern a state has not yet been witnessed in India. Therefore, the probability of imposition of President's rule is also ruled out. Therefore, based on the aforesaid discussion, it can be reasonably inferred that the argument in favor of imposition of emergency, whether in the form of proclamation of emergency or President's rule, lacks legal basis. Even if, based on the foregoing discussion, one reaches a conclusion that the government has acted in contravention of well-settled legal and constitutional principles, a final defense in favor of the measures undertaken by the government could be instituted on the basis of the doctrine of necessity. Often, the government finds justification for its otherwise illegal conduct during a public emergency based on the common law doctrine known as state necessity or simply the doctrine of necessity. Any reliance, if placed upon the doctrine of necessity by the state, would naturally require a strict circumscription by the courts with respect to the standard of necessity imposed. The doctrine of necessity seeks to abridge the often substantial divide between what the law allows the government to do and the actual response of the government during any emergent situation. Here, it must be noted that the doctrine of necessity has no scope of applicability when emergency state action is taken in accordance with specific statutory authority or constitutional authorization. To the contrary, the application of the doctrine of necessity is possible only when a prima facie case is made out to the effect that the government has violated the law. Thus, if the issues discussed in the foregoing discussion indicate that the state prima facie has acted contrary to the law of the land, the actions taken by the state could be justified on grounds of necessity. It may also be argued that the use of the doctrine of necessity becomes most essential when there is a dearth of legislative framework for purpose of guiding the action of the executive in dealing with a public emergency. The extreme brevity and perilous susceptibility of the Epidemic Diseases Act 1897 to the vice of unconstitutionality, the doubtful invocation of the Disaster Management Act of 2005, and the absence of an overarching legislation providing for far-reaching guidelines in respect of dealing with an epidemic is well settled. Under these circumstances, the need to ensure protection of citizens from the perils of a rapidly spreading virus necessarily requires the vesting of powers inclusive of a substantial degree of legislative authority upon the executive. Such usurpation of legislative authority manifested through the prescription of all-encompassing guidelines may be justified on the basis of doctrine of necessity. Therefore, it could be said that the doctrine of necessity essentially pits a seemingly meddlesome court squarely against an executive committed to an unlawful course of conduct purportedly to save the state. Approval to such executive action must be given by the courts very sparingly because in reviewing a state necessity claim, they must consider the legitimacy of readjusting fundamental political, social, and legal values. This consideration must be made in cases where the challenged state action affects individual rights. If due caution is not exercised in granting legitimacy to such executive action, then the power balance shifts too heavily in favor of the executive branch, and courts will become increasingly incapable of ruling against it. Ultimately, for the executive, naked political power transforms into lawful power to exercise its will. It goes without saying that in times such as these, we must pledge our complete support in favor of the government. However, at the same time, we must not lose sight of the critical issues as discussed under the foregoing discussion and as will be discussed in the next part of the discussion.
In this age of pandemics, civil liberties appear to be an elusive luxury. Many prefer the restrictions while others consider it as a necessary evil. We, however, choose to take a different pathway to approach this issue. We take into account medical law experts who have a holistic understanding on how to bring about an effective balance between public health objectives and individual rights. George J. Annas, the William Fairfield Warren Distinguished Professor and Director of the Center for Health Law, Ethics and Human Rights at the Boston University School of Public Health, School of Medicine, and School of Law, which is quite a mouthful, argues that the compulsory and often discriminatory enforcement of public health measures, including but not limited to forcible vaccinations and harsh quarantine enforcements adopted during the smallpox and plague outbreaks in the past century, have not only infringed on individual rights but have also been ineffective and counterproductive to the extent in almost invariably causing accelerated spreads of infection, riots, civil unrest, and widespread public distrust. He derives three pertinent historical lessons from the United States in relation to the utility of such coercive measures. 1. Coercion and brute force are rarely necessary. In fact, they are generally counterproductive as they cause mass proliferation of public distrust and encourage the people who are most in need of care to evade public health authorities. On the other hand, effective preventive strategies that rely on voluntary participation to work. Simply put, rational and law-abiding citizens do not want to contract smallpox, influenza, or other dangerous diseases. They want positive government help in avoiding and treating disease. As long as public officials are working to help people rather than to punish them, people are likely to engage willingly in any kind and all efforts to keep their families and communities healthy. And lastly, one which I think resonates most with the Indian case of pandemic response, which is that in most of these cases, minorities and other socially disadvantaged populations tend to bear the brunt of tough public health measures, resulting in economic hardships, discrimination, and further distrust. He further argues that the threat of a new pandemic will never subside, but the notion that we need to trade liberty for security is misguided and dangerous. Public health concerns cannot be addressed with law enforcement or national security tools. If we allow the fear associated with the potential outbreak to justify the suspension of liberties in the name of public health, we risk not only undermining our fundamental rights, but alienating the very communities and individuals that are in need of help and thereby fomenting the spread of disease. Maintaining fundamental freedoms is essential for encouraging public trust and cooperation. If our public agencies work hand in hand with communities to provide them with a healthy environment, access to care, and a means for protecting their families, rather than treating them as the enemy, we will be far better prepared for a potential outbreak. To value such a balance between public health and civil rights, however, it is crucial that we understand the historical conflict between the said, that is public health and civil liberties. The tension between public health programs intended for communities and individualistic civil liberties is a classic one. In the 17th and 18th century Germany, the medical police were not concerned with this tension. Their surveillance and enforcement activities sought to encourage and maintain the largest population possible. Underlying this effort was mercantilist theories that saw national power as based on large population that could produce goods, engage in trade, and provide increased revenue to the state. They were thus grounded on a primary calculation to augment the power of the state rather than to increase the welfare of the people, so to speak. The early 20th century was different in the sense that while progressives now wanted to use empirical scientific evidence for the purposes of public welfare and social efficiency, it was still identical to the 17th and 18th centuries, as they paid no heed to the coercive nature of such programs by failing to comprehend the antagonism inherent between the state and the public. Dr. Ronald Byer, the professor of sociomedical sciences at Columbia University's Mailman School of Public Health, states that while some of the first recorded conflicts between public health and the acceptability of its adverse measures emerged in the 19th and 20th centuries in the wake of efforts to address chronic conditions that began to inform the pattern of morbidity and mortality in industrial societies, he argues that we continue to ignore such enduring tension between public health and civil liberties at our own peril. His article on the continuing tensions between individual rights and public health, talking point on public health versus civil liberties, develops a chronological sequence on the historical evolution of the conflict between civil liberties and public health in the United States, which makes use of case studies of several states and existing jurisprudences which supported it. Dr. Byer states that while US courts in the 20th century were eager to confer state public health authorities policing powers which would deprive fundamental freedoms often necessary for sustenance and survival, this unchallenged power of public health authorities came under increasing scrutiny during the last decades of that era. The development of a robust jurisprudence of privacy and the due process revolution in the United States, which extended rights to prisoners, mental patients, and others under the authority of the state, ultimately questioned the long-held assumptions that had protected public health from constitutional scrutiny. This groundwork for this profound change was laid in the transformations that occurred in American politics, law, and culture during the 1960s and 1970s. I wholly recommend everybody listening to this episode to read the article. While it defends the prevalence of civil liberties during health crises, at the end of his paper, Dr. Byer also argues that medical surveillance, necessary intervention, and trade-offs when considering social impact assessments are also required for combating viruses. You will have to read it in detail to know more. Taking into account the necessity of medical interventions with respect to civil liberties, the late Dr. Eugene Feingold, former Professor Emeritus of Health Management and Policy, University of Michigan School of Public Health, and former President of the American Public Health Association, argued that minimally intrusive measures which have the potential for significant improvement of public health should be adopted in lieu of stringent, inefficient ones, when moralistic motivations often override legitimate civil liberties and public health concerns. He relied upon studies which screened individuals with consent, maintained confidentiality of responses, identified participants who might benefit themselves from further intervention, and noted that the effects that might also benefit others, including sex partners and future children of the participants, as well as future participants in similar screening programs. In addition to these health benefits, the studies also note that some participants may have been persuaded to be more supportive of public health programs and of government more generally if they felt that the program in which they were required to participate had an additional associated benefit for them. This balancing between public health and civil liberties thus requires the public to make rational decisions based on verified scientific evidence and expert advice given through either public or private authorities. While skepticism towards public administration is often a sign of a healthy democracy, such historically fomented skepticism and a lack of public trust in democratic institutions during public health emergencies make the balancing exceptionally difficult. Yuval Noah Harari, in his article The World After Coronavirus, argues that not only does an appropriate response to COVID-19 require global cooperation, a successful combating would require scientific evidence and public authorities who conduct themselves on such evidence. He argues that because of irresponsible politicians who conduct governance on rhetoric rather than sound policy, public health in democratic institutions are at an all-time low, thereby alluring the same politicians to legitimize authoritarian actions on pretext of the public's non-compliance with directions of said public authorities. So what does civil liberties mean in this pivotal moment of history, and how does an increasingly fragile world protect itself from deadly viruses without arbitrarily infringing on constitutional rights? So what does civil liberties mean in this pivotal moment of history, and how does an increasingly fragile world protect itself from deadly viruses without arbitrarily infringing on constitutional rights? The key is balance and a proportionate response, one that respects rights and freedoms while ensuring that such rights and freedoms are simultaneously protected. That is our take on this issue. Thanks for tuning in. Should we really give primacy of civil liberties over pandemic response in calamitous circumstances? Let us know what you think. Before we conclude, we would like to thank all members of the committee who have helped and supported us through this venture. If you enjoyed listening to our podcast, consider following us on twitter.com/CULawJSC and on Facebook at www.facebook.com/CULawJSC. The full transcript of this episode of the podcast can be accessed at its official Medium page at www.medium.com/il-legality-podcast. Thank you everybody, and please stay tuned for details in our next episode.